So yeah, could you just talk a little bit about what is like the legal definition of entrapment?
Well, the threshold issue in an entrapment case, two threshold issues or elements. One is predisposition, and the other is the inducement aspect. What is used to induce a person? Two things. What do I mean? When they come to you and they lure you in, what are they doing? Do they overboard your will? See, I think it's hard to explain sometimes legally because you're talking about an investigative technique, which is what the FBI use or argue is an investigative technique, versus what the law is. The law, entrapment is a complete defense. If you can overcome the first issue of inducement and the second issue, which is the most important issue, which is predisposition. Because where most people fail is on the element of predisposition. Because in entrapment, you can't be predisposed to be involved in a crime. If you already have an inclination to be involved in a crime, then it negates your entrapment defense. Okay. So we look at the inducement. What's the inducement? And was your will so overborne that you had no choice? Is it money as an inducement? Say you're very poor and they use money to induce you to get involved. What's the mechanism for inducement? And that's why it's so difficult, because as you know, an investigative technique is different than what's done in the law. They're two different ideas. The FBI's investigative techniques can be one of many. One, wiretap cases. Two, informants. Three, surveillance. Four, other type of investigations, your accounts. The Patriot Act gives them a latitude of ways to do an investigation, basically through technological sources, monitoring your bank accounts, monitoring your phone calls, your surveillance, your mail, etc., etc. So these type of techniques are used most of the time. And then you have, see, it's not just a matter of entrapment or an investigative technique. Then you have the doctrine of material support. So they kind of all merge under the investigative techniques, which is a U.S. attorney or prosecutorial tool. You have the statute itself that deals with material support. So that's where many people who have been involved in these cases have a problem.
So material support is who's supporting who?
Okay, in a material support situation, it's akin to, the legal term is when they charge you with conspiracy, or in the federal system it's aiding and abetting. In the state system, it's akin to what we call accomplice liability. And that means that even though you may not be a principal, meaning the person who actually commits the act, okay, and I'm talking about aiding and abetting right now, if you do anything in furtherance of the act, it could be before the act is committed, it could be subsequent to the act committed. You're still an accomplice, or you're still aiding and abetting. And conspiracy is just an agreement between two people to commit an illegal act, and they share the same intent. Same thing for aiding and abetting. You have to have the same intent, because crimes in America are based on what we call mens rea, the intent of the party. And so they would have to show that there was the same shared intent to commit the crime. The problem with conspiracy is that in a conspiracy, once you enter a conspiracy, it's called like a wheel conspiracy. That's an old concept. You're responsible for every act in the conspiracy, even though you didn't commit the act. So, and I don't even have to know who the other co-conspirators are. So, for example, if there's a conspiracy to meet here at my office, okay, let's say it's illegal to meet at my office, much like it's illegal to go to a lot of different places that are on the terrorist list. It's a strict liability. And me and you agree to meet at my office. And when we get there, we're going to talk about entrapment.
Right.
And you call and say, I can't make it, but X is going to appear on my behalf. Right. And we're going to have the same conversation. Well, you have the same intent as the person who's actually appearing. So therefore, you're guilty of the same crime, because if my office was basically on the terrorist list, then that means that we all shared in that purpose and that criminal act of coming to a place we know is designated as a on the terrorist list. I'm just trying to give you some examples.
So if I agree to it, but don't actually carry through with that and show up at the office, I'm still part of the conspiracy.
You're still part of the conspiracy.
So whatever the criminal implications are of being here, I'm still tagged with that.
You're still responsible, yes, because you don't have to be the principal. The principal in the law is actually the actual actor. You
Right.
can be a part of a conspiracy if you give finances to it, if you assist in, for example, in like in 1993 World Trade Center bombing. IAD, okay, wasn't necessarily charged with being in the vehicle that drove the truck to the World Trade Center, but they found invoices that they said he used to order some of the chemicals that were used in this bombing. That made him part of the conspiracy.
Right, right. Just hypothetically, what if he did not know what those chemicals were going to be used for?
More difficult analysis if you don't know, because obviously if intent is a linchpin in a conspiracy, then if you can't agree to something illegal if you don't know what the purpose is. However, the problem is it's hard to prove that you don't know, because that would mean everybody would say, well, I didn't know. So they also look at the totality of the circumstances, because what he did, or what they allege he did, was still in furtherance of the conspiracy. I mean, if there was no contact between the people at all, I mean, you could raise it as a valid defense. I guess ultimately it will be a decision for the jury to determine.
So if there's one guilty conspirator who on tape or wiretap tells the informant that so-and-so is buying these chemicals for this purpose, then that'll be enough evidence, even if so-and-so really didn't know that that was the purpose, but that would be evidence submitted in court, and it could be enough to...
That could be enough to hold them in the conspiracy, yes. Because now they're looking at not just what the informant said, but they're looking at the actual act of the third party.
Right.
Did he buy chemicals? Yes. What did he buy chemicals for? And how were those chemicals used? Those chemicals were used in a criminal act. Because if you just say, well, I didn't know, I mean, that's plausible denial.
Right.
But that's part of the problem with conspiracy or accomplice liability or aiding and abetting, because your act is still in furtherance of a crime.
Right.
Now, I mean, you would have to look at more details. We like to, as attorneys, we use the word, look at the totality of the circumstances to determine what the person's state of mind was, or whether or not they had the same shared intent. So I'm just giving you some general concepts, because you got to take every case on a case-by-case basis, especially in these situations, because they're fact sensitive.
Right.
And normally what the government has is more than just an informant saying A, B, C, and D. They usually try to get everybody who they could rope into the conspiracy to do some act in furtherance of the conspiracy.
They in fact try to do that. I mean,
yes. Because they want to identify all potential targets.
Right. So
should I say threats?
And the FBI agents themselves either are very well versed in the law and know what they have to get to bring people into this crime, or they're being coached by the U.S. attorney. Is it the case where they're sometimes coached by the U.S. attorney?
Basically, first of all, in order to become any law enforcement officer, you have to go to school on what the law is. Part of the academy is they have classes on the law.
Right. They
teach you what the law is, how to make a motor vehicle stop, how to search a vehicle, whatever it is. And obviously, since entrapment is, quote, a defense, a complete defense, they teach agents what entrapment is and what it's not. Now, ultimately, the courts decide, or the juries decide, whether a person has been entrapped, because then it becomes a fact for the jury. You can raise it as a defense, and if the defense is a viable defense, then it becomes part of the jury charge. But in defining what entrapment is, then the jury has the ability to accept your defense or reject your defense.
Right, right. I've noticed that in a lot of the cases, we've run some statistics. There have been about 29 cases of FBI busted terrorist cases, and in 29 total. At 25 of those involved an informant that was very much involved in the whole business. And a lot of these cases, the defendants themselves never testify as if you were a defense attorney, what's the strategy behind not having the
well,
defendant?
a lot of that depends on, number one, the discovery, and number two, you know, you have informants in two separate situations. The first situation is you have a confidential informant who, for whatever reason, the government does not want to disclose. So you may be in a situation where that person would never testify. His information, or the information that they provide, the government just tries to corroborate the information so they can have their own independent mechanism for prosecuting you. But in most of these terrorism cases, the informant is actually available to testify.
Right.
And when the informant testifies, the information or the conduct between the informant and the defendant is admissible. Why? Because one, the act itself is a criminal act, and some things that are said can be considered admissions. That's number one. And number two, you can cross-examine the informant. Right. Because your right to a trial and right to confront your witnesses are not violated because the informant is actually present. There are some circumstances when the informant is not present to testify that testimony is inadmissible. Now, the consideration for whether or not your client should testify, again, is he a single defendant in the case? Has he made admissions that otherwise would not be admissible? Because once a person testifies on the witness stand, they're open to cross-examination by the government. And in certain times, I can only reflect on the cases that I've done. Sometimes you know all of the information that the government has about your client, and sometimes you don't necessarily know. And in the system, they can always put on rebuttal witnesses. They can put on FBI agents, because sometimes you're not privy to all of the information that the agents have in their notes. So if your client testifies, you run the risk of, one, their ability to impeach his credibility. Mm-hmm. Two, not everyone is a good witness. You know, we even know from our own experiences as Muslims, we know that Musa had Aaron speak for him. Right. Because he wasn't articulate. He right. stuttered. You have the same system, you have the same situation in the criminal system. Right. The attorney is like Aaron. Right. Your client is like Musa. And sometimes the client doesn't have the ability to articulate a defense. And also, people aren't really sympathetic to your side of the story. And you may look at it and say, you know what, he's better off not testifying. And the other additional consideration is, when a person testifies at trial, if the jury convicts him, then on appeal, the appellate division can just say, well, listen, jury didn't find him credible. There are no legal issues to be decided. So, you know, a lot of considerations, again, it depends on the client, it depends on the discovery in the case, the background of the client, his ability to communicate, whether or not his temperament, his disposition if he were to take the stand. So, you know, there are many considerations on a case-by-case basis as an attorney that you have to basically analyze.
Okay. Now, you said that one of the important aspects of determining whether or not there is entrapment or not is predisposition. So, how far does a prosecutor have to go in determining or proving that there was predisposition to this crime before an informant or someone got involved?
Well, he would have to negate the element of predisposition, because the burden of the prosecutor is the proof beyond a reasonable doubt. Right. Entrapment is an affirmative defense. Right. Okay, but what happens is it's a concept that's hard to explain. What do we mean by predisposition? Okay, they infiltrate a mosque. They start talking to people, and a person is an informant. He starts recording conversations, and he's just speaking generally. First, he finds out, what's your views on, say, what's going on in Palestine, what's going on in Iraq, what's going on in Syria. Now he can identify you, or someone can identify you based on your, quote, political views. The next step is, now we know your political views. Well, how committed are you to your political views supported by your alleged spiritual perception or concepts? Right. So what they do is, I mean, they know people. they then send people in, and after a while, the conversation is a transition in the conversation from politics to what can we do to make a difference.
And the informant makes that transition.
Right.
And they're allowed
subtle.
Yeah.
Or sometimes, you know, people who really may not be predisposed to commit crime, but do what we call puffing, want to sound important, sound tough.
Yeah.
You know, we all know people who want like to sound tough.
Yeah.
And they say, oh, shit, man, listen, I'm down with suicide bombing because I would do that myself. Now the informant knows that there's some predisposition. Now the only thing is to understand the person.
But then you got them on tape too. So.
Right, you got them on tape. So okay, what are the needs of this person? Person doesn't have money, you know. So now you induce him with the money. But see, he's already showed you that he's predisposed. It's not a measure of how much he's predisposed, just the idea that he would agree or say, you know what, if I had the ability, I'd do it myself.
Right. So yeah, I mean, and in fact, yeah, I mean, puffing is the first time I heard that term.
Right.
But that can be turned into evidence that you were predisposed. That's enough to do it.
Right. That's enough to do it because an objective person doesn't know that you're puffing. Right. You know, you make it sound real. Huh.
Yeah.
Shoot, I would do that because, you know, I know if I go down, I'm going to heaven.
Yeah.
You know what I'm saying?
Yeah.
I'm going to die as a martyr.
Right.
And, hey, listen, I ain't got nothing else in my life. I want to die as a martyr.
Right.
You know, this time. That's why I always say to people that you should never have conversations, flipping conversations with anybody.
Right.
About anything criminal.
Right.
Rather it's drugs, weapons, because you don't necessarily know who you're talking to.
You should almost assume that you were being recorded.
Right.
Yeah, there was a case with the Fort Dix defendants where the informant essentially accused one of the defendants of being a coward in front of his wife.
Right.
And just to save face in front of his wife, he said, okay, I'll do something. And that's literally what he said, okay, I'll do something. And that was used as the case for predisposition.
Right, because he says, because in the context of, okay, I'll do something, you're agreeing to do something, which is implied. If I challenge your manhood and say you're a coward because you want to be law-abiding, and you say, okay, I'm going to prove to you I'm not a coward, the only thing you can do is something illegal. That's the inference from the words that were used, and also that gives you predisposition.
And it's a tool on the part of the informant, right, to be able to get you to cross that line into predisposition so that they can use that as evidence.
It's an ego that he hit a chord on his ego. Right. Because he felt it was more important to impress his wife than to maintain his position, which was a legal position and could not be misconstrued into a position that is somewhat ambiguous that could be interpreted by others. Right. Because now, as a prosecutor, I can use those words, or I can interpret those words, or translate those words based on implication and inference. Right.
So then after that, they actually have to take some step towards this illegal act.
Are you talking about for entrapment?
Yeah.
For entrapment, yes.
Yeah.
For conspiracy, not necessarily. Okay. For conspiracy, the agreement itself is the crime.
Okay.
Now, the agreement, you can get prosecuted for an agreement to commit an illegal act. But normally what happens is there's some overt act that's contemporaneously with the agreement, or at some point there's some overt act that can be identified as part of the conspiracy, either by the person himself or by some other third party.
Okay. But for an entrapment for a prosecutor to counter an entrapment argument, they would need the defendant to actually
commit some act. Yes.
Commit some act that would have to be actually an illegal act,
or substantial steps toward an illegal act. Yes.
A substantial step. So it doesn't even have to be illegal.
Yes, it has to be illegal because otherwise you wouldn't be in court.
But a substantial step towards an illegal act. So
right.
That step.
In furtherance of some illegal act. For example, I'm going to rob a bank, and I say to you, you know, I'm going to go down here and rob Bank America. I don't have a car. And you say to me, hey, you want to use my car? I'll say, yeah. You give me the keys, I use your car. Now, you already know that my purpose for using your keys is to rob a bank. You've agreed to a conspiracy. You didn't do anything but give me your keys. But it doesn't matter.
Right.
It's an illegal act. At that point, you're assisting me. You're helping me further the crime.
Right.
So that part of it is a conspiracy. In entrapment, you would actually have to do something, because the only way you can raise the defense of entrapment is when you commit the illegal act and then say, I would not have done it had not I been induced by the federal government.
Right.
Or by some informant, etc.
But the inducement, I mean, that's the, you know.
Well, that's what the issue becomes. What is the inducement? Was there inducement? And even if it was some inducement, did it overboard your will? And second, most important, were you predisposed to do this even without the inducement? Was this something you would have committed? Was this conduct you would have participated in even if there was no inducement?
But could calling you out as a coward in front of your wife be considered inducement?
Again, that depends on what the jury believes.
Okay, so that could...
Yeah, it's a jury fact. All of this is for, ultimately, these are questions for the jury. Right. Even conspiracy is a question for the jury, because the way a trial goes is the state puts, or the government puts on their case, the defense, if they choose to do so, puts on a case, or they can rest, because you have no obligation in theory as a defendant to defend yourself. It's the state's burden or the government's burden to prove you guilty beyond a reasonable doubt. Now, if you raise what we call an affirmative defense, then the government has to knock out those elements, because whatever the defense is or the crime is, they have elements that they have to prove. The state has to prove. That's the burden. Prove those elements exist. If they knock out, for example, in entrapment, if they can show that you're predisposed to participate in the crime, then your defense falls. If they can't show that, then your defense, the jury can find you not guilty, but the jury gets a chance to evaluate all the facts and circumstances of your charges and your arrest. And I mean, obviously politics plays a part, you know, type of jurors you have, sympathy, lack of sympathy. You know, even though the judge says you're not supposed to decide this case based on anything but what you hear in the courtroom, not sympathy for the state or the defendant, but just on the facts. We're human beings.
Sure. And
always the elephant in the room in terrorism cases are this sense of patriotism. I once tried a terrorism case with a U.S. attorney because she thought that my guy might get acquitted, got up, started talking about the flag, and started crying. And it put me in a very uncomfortable position because she was a woman, blonde hair and blue eyes, started talking about how she loved America, appealing to the patriotism of the jurors. So if I object, then I'm putting emphasis on it. If I don't object, it's like it was real uncomfortable. Mm-hmm. You know, and in that case, they had surveilled my client from like December 1st of 1998, of 1999. Yeah, from December 1st of 1999 through January 20th of 2000. At the turn of the millennium, when they were concerned about this terrorist act, they had 24-hour surveillance on the person. When he left his home, every place he went, they had him surveilled. When he picked people up at the airport, everything. And what happened is they waited 3-4 years later and they came back to him and said, in 1999, you picked X up from the airport. Do you remember that? He said, I don't remember that. He said, yeah, you picked him up. I have no contact with him. They didn't bother him. They waited another year or two. They came back again. Now, they said to him, we're investigating the act of terrorism. And we want to talk to you. Brought him in, sat him down, asked him all of the same questions they had asked him previously. He gave them many of the same responses. They indicted him for obstruction. But because it was an obstruction that related to a terrorism investigation or material support, he then became life eligible.
Right.
Because he gets enhanced.
Right.
And we tried the case, and you know, he got blessed because he wound up only doing like maybe 5 years. But you know, and when I say they literally had him under surveillance, they had video footage, they had a log of when he would leave his house, who he would leave his house with, the names, everything.
Right. If the FBI were to stick an informant on a Muslim in America today, and then bring a case of terrorism against a Muslim in America today in a federal court, do you know of any cases where they've ended up with acquittal?
Not many, but you know what's interesting? I think it was maybe 2006 or 2007. I was part of the roundtable in London at Oxford University, and it was the 50th anniversary of Brown versus the Board of Education. And there were attorneys and people there from all over the country in the U.S. And we started talking about these terrorism cases. And it was interesting because there were people from the West and parts of the Midwest where they were bringing terrorism cases and people were actually getting acquitted.
Really?
Yeah. But on the East Coast, I can't even, I'm not aware of anybody who actually went to trial on the East Coast that got acquitted. I'm not aware of anybody. Okay. I think that's virtually, I mean, I don't want to say it's virtually impossible, Allahu A'lam, but it's very difficult because we're so saturated with the propaganda of, not just propaganda, but the realism of terrorism because of 9/11 in 1993, when people actually physically were involved in being victimized, and you know, it ran on TV constantly, and the threat of terrorism to most Americans is real,
right? Especially
on the East Coast,
right?
The closer you live to New York City or Washington D.C., the more likely you are to believe that this is a real threat, and that, you know, innocent people could be killed as part of the aftermath. So it's very difficult.
Wow. Anything else?
No, I think we covered it pretty much. Okay, I'm going to stop rolling. I'm going to stop right now.